Good afternoon, everyone.
Good afternoon.
Good afternoon.
Hello.
Before we begin, could you please silence your cell phones? Today's hearing is being live streamed on YouTube. And I believe the live stream has started already. Welcome to the Office of Tax Appeals, or OTA. My name is Stephen Kim, and I am the lead administrative law judge, or ALJ, for this oral hearing. The hearing reporter, Ernalyn Alonzo, is present and reporting this hearing verbatim. To ensure we have an accurate record, please speak clearly and avoid speaking over one another. If needed, Ms. Alonzo or any panel member will interject to ensure we have a proper transcription. After the hearing, Ms. Alonzo will produce the official hearing transcript, which will be available on OTA's website. OTA is not a court. OTA is an independent and impartial appeals body staffed by subject matter experts. OTA is separate from any tax agency, including respondent, California Department of Tax and Fee Administration. While OTA is not a court, we must still follow certain guidelines to conduct an orderly hearing and establish a proper record on which the opinion will be based. Each party will have the opportunity to be heard, so please wait for your turn to make your presentation. Please do not interrupt the other party's presentation and refrain from making any excessive noise or gestures during the other party's presentation. As lead ALJ, part of my role is to keep the hearing on track, so I may interrupt the hearing if you become counterproductive. Before we go on the record, Mr. Gustafson, do you have any questions about anything I've just said?
No, I do not.
Respondent, do you have any questions?
No, I don't. This is Kevin Smith.
All right. Judge Ridenauer, Hearing Officer Wilson, are you ready to proceed? All right. And Ms. Alonzo, are you ready to proceed? All right. Everyone gave a thumbs up. We are now going on the record. This is the appeal of Eaton Corporation. OTA case numbers 2212-12041 and 2303-12830. The date is January 21st, 2026, and the time is 1:06 p.m. This hearing is being held electronically on Zoom with the agreement of both parties. I am Judge Stephen Kim. I will be the lead ALJ for the purpose of conducting this hearing. My co-panelists are Judge Shireen Ridenauer and Hearing Officer Kim Wilson. We are equal participants in deliberating and determining the outcome of this appeal. So parties, if you could please state your name and who you represent and your title, starting with appellant.
I am Tim Gustafson with Eversheds Sutherland, appearing on behalf of Appellant Eaton Corporation.
Thank you.
And
And is Mr.
Hello,
Sorry.
I'm Mike Rosilli. I am Director of State and Local Tax Strategy for the taxpayer Eaton Corporation.
Thank you. And for respondent, California Department of Tax and Fee Administration, or CDTFA.
This is Kevin Smith. I'm from the CDTFA Legal Division.
This is Jared Noble. I'm an attorney with the CDTFA's legal division.
And I'm Jason Parker, Chief of Headquarters Operations Bureau with CDTFA.
Thank you. The issue to be decided in this appeal is whether appellant is entitled to relief of any tax and interest under Revenue and Taxation Code Section 6596, based on reasonable reliance on written advice from CDTFA. Mr. Gustafson, is this the issue on appeal?
it is.
And Mr. Smith, do you agree?
I agree.
Thank you. Appellant submitted exhibits 1 through 6, and CDTFA did not object to these exhibits. Therefore, exhibits 1 through 6 are now admitted into evidence. And CDTFA submitted exhibits A through L. Appellant did not object to the admissibility of these exhibits. Therefore, exhibits A through L are now admitted into evidence. And at the PHC, the pre-hearing conference, both parties indicated that they do not intend to call any witnesses. Just to clarify, Mr. Vasili is here as a he won't be testifying as a witness. Is that correct?
That is correct.
Okay. All right, Mr. Gustafson, you'll have 30 minutes for your presentation, and you may begin when you're ready.
Well, thank you very much, Judge Kim, Judge Ridenour, and Hearing Officer Wilson. Now we're here today on two consolidated appeals involving tax periods 2011 to 2013 in the first appeal and 2014 to 2016 in the second appeal. But this case involves 4 audits. Audits for the 2 periods subject to these appeals and audits for 2 prior periods. And those are 2005 to 2007 and 2008 to 2010. So as a little, maybe a bit of preliminary housekeeping, I'll refer to the audit for 2005 to 2007 as the first audit, the audit for 2008 to 2010 as the second audit, the audit for 2011 to 2013 as the third audit, and no surprise, the audit for 2014 to 2016 as the fourth audit. I will also refer to the first and second audits collectively as the prior audits. So with that in mind, there are some important consistencies across all 4 audits. And the first involves the facts, which remained consistent. Eaton, the taxpayer, engaged in the same business during all 4 audit periods. Eaton manufactures, sells, installs, and maintains high-end power management products, such as switchgear, circuit breakers, sensors, and uninterrupted power supply or UPS products. On the last one, the UPS products, Eaton has been manufacturing those for over 60 years. Eaton operates sales and service facilities in various California locations, and in fact has been operating in California for over 100 years. Eaton contracts with a variety of customers, including the United States government and its agents, located inside and outside California. But again, Eaton made, sold, and installed the same products across all 4 audit periods, including those UPS products. Eaton entered into transactions with the U.S. government and transactions with private entities across all 4 audit periods. So that's the first consistency across the audits. The second consistency, and an important one, involved the audit themselves and the fact that the auditors examined Eaton's sales and its transactions with the U.S. government. That's the key consistency. Now, there was one critical difference between the first 2 and the last 2 audits, and that's really why we're here today. While the first 2 auditors concluded that Eaton's sales to the U.S. government were exempt sales, the last 2 auditors reached a different legal conclusion, and that was that Eaton's sales to the U.S. government were construction contracts, and consequently, CDTFA determined that those last 2 auditors determined that certain purchases related to performing those contracts were taxable. So we've got these 4 audits, and we have this critical distinction between what happened in the first 2 and what happened in the last 2. And this case then really raises the question, what is the purpose of an audit? And CDTFA regulation 1698.5 subdivision B1 tells us that the purpose of an audit is to determine whether the taxpayer reported the correct amount of tax. Now, if a taxpayer does not report the correct amount of tax, then the auditor tells the taxpayer what it did wrong. And by implication, the auditor also tells the taxpayer what it did right in an audit. If a taxpayer reported the correct amount of tax, then there are no adjustments. If the taxpayer did not and did something wrong, then CDTFA will make an adjustment. And then the taxpayer is supposed to correct what it did wrong going forward and to continue what it did right going forward. Eaton, as a corporate taxpayer, is very familiar with this process. It collects, reports, and remits millions in sales and use taxes each year to California. CDTFA and the State Board of Equalization before it routinely audit Eaton's California sales and use tax liability. And in each audit, the state tells Eaton what it did wrong, if anything, and confirms what Eaton did right. Here, in this case, there wasn't just one, but two audits where the state told Eaton that how Eaton treated its sales to the U.S. government was right, that these were exempt sales. Consequently, Eaton continued to treat its sales to the U.S. government as exempt sales and to report those transactions accordingly into the periods at issue in these appeals, carried forward into 2011, 2013, 2014 to 2016. It wasn't until 2017, which is after the close of the fourth audit period, that CDTFA, or Board of Equalization, told Eaton that Eaton was wrong about these transactions for the first time. Revenue and Taxation Code, Section 6596, and CDTFA Regulation 1705, which we're going to discuss a little bit more in detail, say that a taxpayer gets to rely on what the auditor says it did right. And that's what Eaton did. Eaton never had a chance to correct what CDTFA said was wrong in the 6 years after being told that it had been doing things right. Now, regarding the law, Section 6596 provides for relief from sales and use tax liability when a taxpayer's failure to pay such tax is due to reasonable reliance on written advice from CDTFA. And there are 4 conditions for relief under the statute. Taxpayer made a written request to CDTFA. CDTFA responded in writing regarding the request, stating whether the described, quote, activity or transaction is subject to tax, end quote. Taxpayer in reliance on the advice did not collect sales tax or pay use tax, and 4, the tax liability applied to a transaction or activity which occurred before CDTFA sent the taxpayer written notice of rescinding or modifying the advice. Then only the second condition is at issue in these appeals, and specifically is set forth in CDTFA Regulation 1705 Subdivision C. The issue here is whether the prior audit documentation constituted written advice by demonstrating that, quote, the issue in question was examined, end quote, or alternatively, that, quote, the activity or transaction in question was properly reported and no amount was due, end quote. The issue in question in these appeals was the nature of Eaton's sales of tangible personal property to the U.S. government. Similarly, the activity and transactions in question were the sales themselves. And this issue was examined by the first auditor. We know that by looking at the work papers for the first audit. For example, the auditor labeled Eaton's sales to the U.S. government as exempt in the work papers. And these are found at Appellant's Exhibit 3, pages 8 and 9, and also at 23. Additionally, from the audit work papers, we know that Eaton sold UPS products to the U.S. government, and Eaton performed services for the U.S. government. These are found at Appellant's Exhibit 2. These are invoices, pages 1, 4, and 5, and for the UPS products, and 3 for the services. The auditor in the first audit also reviewed a large number of exempt labor invoices and optional maintenance invoices. The Appellant's Exhibit 3, pages 1 through 4 for the former and 4 through 8 for the latter, as well as invoices showing installation. Appellant's Exhibit 3, pages 24 to 27. These are invoices. So the auditor examined Eaton's transactions with the United States government, knowing the types of customers, the property sold, and the accompanying services performed. And based on this examination, the whole context of it, the auditor concluded that the transactions with the U.S. government were exempt sales. Now, turning back to Regulation 1705 Subdivision C, that provides that, quote, audit comments, schedules, and other writings prepared by the board that become part of the audit work papers which reflect that the activity or transaction in question was properly reported and no amount was due are sufficient for a finding for relief from liability unless it can be shown that the person seeking relief knew such advice was erroneous, end quote. Well, Eaton properly reported its sales to the U.S. government, and no amount was due from those transactions. The auditor agreed with Eaton that the sales were exempt. Together, under the regulation, that's sufficient for a finding of relief from liability. Eaton certainly didn't know that the advice that its sales to the U.S. government was exempt was erroneous, and that's what it was challenging in the third and fourth audits. Eaton challenged the legal conclusion that Eaton was a U.S. construction contractor. Turning to the second audit, really the second auditor makes our case for us. And the second auditor relied on the legal conclusion drawn by the first auditor. As CDTFA notes in its briefing, the second auditor refined Eaton's U.S. government invoices out of the audit sample. He didn't need to see them. Why not? Well, because the first auditor had determined that such sales were exempt. So the second auditor relied on the determination of the first auditor, and that's exactly what Eaton did. And that's what the statute and regulations say Eaton can do. Now, CDTFA, for its part, disagrees with us on the relevant issue in question, or the activity or transaction. CDTFA contends that issue is whether Eaton paid use tax on its purchase of materials and fixtures acquired to perform construction contracts. But this presupposes that Eaton is a United States construction contractor under Regulation 1521. And there are a couple of problems with this presupposition. First problem is that the determination of whether Eaton is a construction contractor, a U.S. construction contractor, is a legal one, not a factual one. And we include a number of citations at pages 2 and 3 of our consolidated supplemental opening brief demonstrating this point. And legal determinations are what a taxpayer is entitled to rely on under our 6596, Section 6596. For example, if an auditor gives written advice telling a taxpayer that product X is exempt, then the taxpayer is entitled to relief from liability on its sales of product X, even if CDTFA later comes back and says that product X is taxable. Only after CDTFA notifies the taxpayer of that change or correction, then the taxpayer can no longer rely on the prior determination. Second problem for CDTFA is that the legal determination for a construction contractor doesn't depend on a taxpayer's purchases. That determination is driven by a taxpayer's sales, its transactions with the counterparty. So here, the U.S. government. Here, that's Eaton sales to the U.S. government, which were examined during the first audit. The first auditor did not conclude that Eaton was a United States construction contractor. Didn't even conclude that Eaton was a construction contractor at all. And this is even though Eaton engaged in the sale and installation of the same products with non-governmental entities that it did with the U.S. government. And neither did the second auditor. He didn't conclude Eaton was a construction contractor either. It's interesting to note that the second auditor reviewed a refund claim that Eaton had made for tax accrued for a different California construction contractor. Right, so the topic was even on the table during the second audit, but that auditor did not find Eaton to be a construction contractor. And CDTFA concedes this point in its Respondents Exhibit B at page 24, where it says, quote, nowhere in the prior audit reports was Eaton referred to as a construction contractor, they were classified as a seller of equipment, end quote. So both auditors examined Eaton's transactions and neither concluded that Eaton was a construction contractor of any kind, but instead is classified as a seller of equipment. Sales of equipment are not construction contracts under Regulation 1521. CDTFA also concedes that the prior audit work papers do indicate that purchases were examined or reviewed. This is at Respondents Exhibit B, page 23. But CDTFA downplays this fact, asserting that the first two auditors were looking at the wrong purchases and that Eaton's purchases of, and quote, Eaton's purchases of materials to manufacture UPS systems and other property that is considered a fixture as defined in Regulation 1521 were never examined in the prior audits, end quote. Well, again, this presupposes a legal determination that UPS products were fixtures under Regulation 1521 and not machinery or equipment. But again, the prior auditors classified Eaton as a seller of equipment, and that's according to CDTFA itself. Neither found Eaton to be a construction contractor of any kind. And additionally, as a factual matter, we know that the second auditor reviewed Eaton's purchases of maintenance parts consumed, over 600 of them. And these show up in the work paper at the work papers at Respondents Exhibit L, pages 174 to 205. And these parts included multiple UPS related items, UPS product related items. And those show up at various rows throughout those work papers, pages 175 through 178, 180, and so forth. But it's not, the purchases aren't the issue here. The issue that matters is sales. And because it's a taxpayer's sales that determine whether it is a construction contractor or United States government construction contractor, not its purchases. Only after that determination is made do particular purchases matter, or particularly the ones that are giving rise to the liability in the appeals here. The first two auditors examined Eaton's sales to the U.S. government and concluded that they were exempt. The first one by taking a look at the sales, the second one by relying on what the first auditor said. Now, these first two auditors made these legal conclusions and told Eaton what it did right and what it did wrong accordingly. But even if these auditors drew the wrong legal conclusions, Eaton still was entitled to rely on that advice. CDTFA Regulation 1705 contemplates the possibility of auditor error. And written advice under the regulation expressly includes advice that was, quote, incorrect at the time it was issued, end quote. And this is in Reg 1705 subdivision A3. Now, CDTFA now says that the first two auditors made a, quote, judgment call that turned out to be wrong. And this is Respondents Exhibit B, page 25. Eaton is entitled to rely on that judgment call. A judgment call made by auditors required by CDTFA to be familiar with the provisions and requirements of the laws they are administering, including the sales and use tax law. And these judgment calls that auditors make are even presumed to be correct by law. So Eaton can rely on those, and reasonably so. And that's what it did. Now, CDTFA can reverse itself when it comes to the application of law to particular facts. Say this item, we consider it equipment. Now we consider it a fixture. Not a construction contractor. Yes, a construction contractor. CDTFA can come in and take that other position, that reversal. Taxpayer can't be expected to anticipate that reversal, and certainly not be penalized for doing so. Here, for example, having 6 years of doing the same thing that the first two auditors said it should do in terms of treatment of Eaton sales to the U.S. government, before hearing that that treatment is now wrong. Eaton had no opportunity to correct course during that period. And that's what Section 596 is designed to protect against. At this point, I just wanted to turn to Mr. Rosilli and just ask if he, as just the taxpayer representative, anything to add to our argument.
I realize, and I'm not making a legal argument here. I'm just saying from a taxpayer's perspective. Again, you get an audit report. It tells you what you did wrong, but it also tells you what you did right. So you're going to continue to do what you think you did right, and try to correct what you did wrong. And from our perspective, again, why would we change anything going forward? And just the nature of the audits, and these things take time. Again, we were dealing with an audit from 11 through 13 that we didn't get essentially audit work papers and reports for until 2017. So again, that period is already, there would be no chance for us to ever correct that, just by what the information we had from the state of California was telling us we were doing these transactions right. We wouldn't change anything. And again, now that they're telling us we had potentially done it wrong, we'll look into making corrections on that. But just from a taxpayer perspective, just, we feel hamstrung with what could we have done in that situation, other than, again, bog it down even more, which I don't think is the intention of any of the parties to. So that's all I had.
Thank you. So just to wrap up, Eaton reasonably relied on the advice rendered in the first and second audits. It told what it was doing right, and it continued doing what it was doing right, namely reporting its sales to the U.S. government properly. Section 6596 was enacted to protect taxpayers in precisely this situation. And so when Eaton continued to report its transactions based on this advice, that's what it says 6596 allows for, until Eaton is put on notice that the advice will no longer be followed, or there's a correction from CDTFA, which CDTFA did for the first time in 2017, which was after the close of the 2 audit periods at issue in this appeal. And so for these reasons, we submit that Eaton is entitled to relief from liability related to its transactions with the U.S. government during the periods in issue. And to the extent we need additional time to reserve for responding to questions or rebuttal, we do so. But thank you very much.
Thank you for your presentation. Let's see if my panel has any questions. Hearing Officer Wilson, did you have any questions for appellant?
I think I might, but I'm going to hold off until after CDTFA's presentation.
Okay, Judge Ridenhour, did you have any questions at this moment?
Yeah, just a couple real quick, if you don't mind. So just to confirm my understanding is correct, during the prior audits, none of the contracts were examined. Is that correct? It's just the sales invoices, Mr. Cook?
That is correct. I don't believe we have any contracts with the U.S. government as part of the record here.
I was reviewing, I've looked over the sales invoices in preparation, for this hearing, and I was unable to find any of the sales invoices that would have gone to installation, right? To give them, is that correct? I was looking at it and I couldn't see anything about installation or something that would give the impression of general contractor. If I'm misunderstanding that, I was hoping maybe you could point me to one.
Sure. The one invoice so there are invoices with installation, and those would be at Appellant's Exhibit 3, pages 24 through 27. And these particular invoices, as part of the sample, were not for to government entities, but just as part of what Eaton does. Those are invoices to non-government entities showing installation for the first audit.
I apologize. I guess I should have narrowed my question to sales invoices to the government, but there isn't any installation invoices, sales invoices to the government that include installation, just private entities like the ones you just pointed out.
There are an invoice showing services to the U.S. government, but it doesn't specifically say the word installation.
Okay.
This is
I just,
exhibit 2, page 3, for example.
got it. Okay. Thank you. I just wanted to make sure I wasn't missing anything. Thank you very much. No more further
You're welcome.
questions.
Thank you, Judge Ridenhour. I will reserve my questions for after CDTFA's presentation as well. Mr. Smith, you reserve 20 minutes for CDTFA's presentation, and you may proceed when you're ready.
Thank you. Good afternoon. At issue today is whether appellant is entitled to relief under Section 6596 based on prior audit advice. Appellant is a multinational corporation and was engaged in business in California during the liability period, selling power management products and other property to its customers. Upon review of appellant's books and records for the liability periods, the department found that, among other things, appellant erroneously recorded transactions as non-taxable sales for resale and disallowed some of those sales. Among the disallowed claimed non-taxable sales for resale were transactions where the department determined that appellant failed to report and pay use tax in connection with his performance of construction contracts with the United States. There are also related audit measures for fixtures and materials the appellant acquired without paying tax and consumed in the performance of those construction contracts. Appellant contends that it reasonably relied on erroneous written advice given by the department during prior audits in reporting its use tax obligations connected to construction contracts with the United States. California imposes sales tax on a retailer's retail sales in the state of tangible personal property, measured by the retailer's gross receipts, unless the sale is specifically exempt or excluded from taxation by statute. For example, gross receipts from the sale of any tangible personal property to the U.S. government is exempt from the computation of the amount of sales tax. When sales tax does not apply, use tax applies to every person storing, using, or otherwise consuming in the state tangible personal property purchased from a retailer, unless that use is specifically exempted or excluded by statute. A purchaser who gives a resale certificate or purchases property for the purpose of reselling it makes any storage or use of the property other than retention, demonstration, or display while holding it for sale in the regular course of business. The storage or use is taxable at the time the property is first stored or used. Now, gross receipts from the sale of any tangible personal property to the U.S. government is exempt from the computation of the amount of sales tax. However, United States construction contractors are consumers of materials and fixtures which they furnish and install in the performance of contracts with the U.S. government. And either the sales or the use tax applies with respect to sales of tangible personal property, including materials, fixtures, supplies, and equipment to contractors for use in the performance of such contracts with the U.S. For the construction of improvements on or to real property in the state. Furthermore, a contract to repair a fixture in place or a fixture the contractor is required by the contract to reaffix to the realty is also a construction contract. A United States construction contractor is a consumer of the parts furnished in the performance of construction contracts to repair a fixture. Under Revenue and Taxation Code Section 6596, If the department finds that a person's failure to make a timely return or payment was due to the person's reasonable reliance on written advice, the person may be relieved of the taxes imposed and any penalty or interest. If a previous audit of the person requesting relief contains written evidence demonstrating that the issue in question was examined, either on a sample or actual basis, such evidence will be considered written advice from the department. Audit comments, schedules, and other writings prepared by the department that become part of the audit work papers, which reflect that the activity or transaction in question was properly reported and no amount was due, are sufficient for a finding for relief from liability, unless it can be shown that the person seeking relief knew such advice was erroneous. To the extent appellate asserts that it did not perform construction contracts for the United States government, and as more fully explained in the decision, we note that the department determined that appellant was liable for unreported use tax upon the parts, materials, and fixtures that are furnished and installed onto real property in the performance of construction contracts with the United States. Therefore, in order to be entitled to relief under Section 6596, the appellant must establish that prior audits reviewed its construction contracts with the United States and informed an appellant that it was reporting tax correctly on those transactions. Here, the documentation provided shows that during prior audit 1, which covered the period January 1, 2005 through December 31st, 2007, the department only examined sales invoices that showed sales of tangible personal property by appellant to its customers. That is, there is no evidence that the department examined transactions or contracts where appellant furnished and installed or repaired affixed fixtures for the U.S. government. In contrast, during the audit at issue, the department reviewed invoices in detail and discovered transactions for installation or repair services that led the department to conclude that appellant was a United States construction contractor. For instance, and this is for the previous audit 1, the NASA Dryden Flight Research Center invoice, which is page 440 of the hearing binder, shows charges for UPS receptacle, external battery pack, 4-post rail kit, and an SMMP web card. The Veterans Administration invoice, page 441 of the hearing binder, shows charges for UPS, split phase power modules, and battery modules. The Sverdrup Tech Inc. invoice, which is page 442 of the hearing binder, shows charges for remote packing mechanism. And finally, the U.S. Navy Military Sea Lift Command invoice, which is page 443 of the hearing binder, shows charges for lighting circuit material. All of these invoices are just for direct sales of tangible personal property. Furthermore, upon a review of the invoices for the USA Navy Military Sea Lift Command, page 444 of the hearing binder, which shows charges for services, labor, and M-service labor and material, 30% of order completed. And the Sverdrup Tech Inc. invoice, page 445 of the hearing binder, which shows charges for breaker reconditioning, plus required parts. And the Bureau of Reclamation invoice, page 446 of the hearing binder, which shows charges for progress payment number 3. After reviewing all of those invoices, there aren't any indications on the face of the invoices that appellant sold tangible personal property to the United States in transactions where it also performed installation and/or repair services. Notably, none of the invoices mention installation services. Further, the USA Navy Military Sea Lift invoice does not describe the type of labor provided or the context in which it was provided. Similarly, the invoice reflecting progress payments do not indicate the nature of the project for which progress payments were being made. Likewise, appellant service of reconditioning a breaker are not synonymous with repair services for an affixed fixture, because there is insufficient information on the face of the invoices indicating where the breaker was located, or if it was attached to real property. Further, the spreadsheet with appellant sales information, which is page 447 to 458 of the hearing binder, lacks important details about the nature of the transaction that the department purportedly examined during prior audit 1 and deemed exempt. Specifically, whether any of the transactions involved furnishing and installing fixtures onto real property. With regard to prior audit 2, which covered the period January 1, 2008 through December 31st, 2010, the department agrees that some of the invoices show that appellant installed, affixed, or repaired a fixture using tangible personal property, which is sold to the United States government. However, these invoices were not reviewed by the department because the department excluded all U.S. government transactions from the scope of the audit. In other words, these transactions were not part of the audit. This is shown in 2 emails sent by the department to appellant, pages 459 to 462 of the hearing binder. The emails contain an Excel spreadsheet with a question list of transactions and requested invoices and purchase orders related to those transactions. Importantly, none of the questioned transactions involve sales to the United States because the department had excluded them from the scope of the audit. Thus, there is no evidence contained in Audit 2 showing that the department examined sales of tangible personal property in connection with the United States construction contracts. Accordingly, the department was unaware that appellant sold tangible personal property to the United States in transactions where it also performed installation and/or repair services, and certainly did not inform appellant that it was reporting tax correctly. Therefore, the evidence shows that the books and records provided upon audit in prior audits 1 and 2 did not fully describe the fact that appellant sold tangible personal property to the U.S. in transactions where it also performed installation and/or repair services. This shows that the department in prior audit 1 and 2 did not examine the activity or transaction at issue here, and thus no erroneous advice was provided. Now, the facts here are similar to Oda's presidential opinion in Salam and Praveen. In that case, the taxpayer asserted that it provided the department with documentation sufficient to disclose the existence of third-party rebates, and that the department erroneously failed to inform the taxpayer that those rebates were taxable. In Salam and Praveen, it was concluded that no relief could be granted under Section 69596 based on an audit or an audit report that failed to notice an error. Accordingly, the evidence from both prior audits does not show the department examined the exact activities or transactions in question. It further shows that the department was unaware that appellant sold tangible personal property to the U.S. in transactions where it also performed installation and/or repair. In other words, construction contracts. Based on all of the foregoing, we find that appellant has not established that it is entitled to relief under Section 6596 based on erroneous advice received from the department during prior audits. This concludes my presentation. Thank you. But Mr. Noble would like to provide a few additional comments in rebuttal to appellant. Thank you.
Good afternoon. This is Jarrett Noble. In rebuttal, we reiterate that it is not enough to just provide all records during an audit in order to qualify for relief pursuant to Section 6596. The statute requires that the issue be actually examined in an actual or census review and inform the taxpayer the tax was reported correctly. Despite the assertions by appellant made during this appeal, the department excluded sales to the U.S. government in one of the previous audits and only saw direct sales without installation of tangible personal property in the other. A wrinkle unmentioned by appellant is that they made both sales of TPP without installation to various parties, including the U.S. government, but also on occasion installed them for the customer. There is zero evidence that department staff were provided with invoices that were examined as part of the audit that demonstrated installation of fixtures onto real property. Furthermore, per the briefing, appellant repeatedly asserted that it was not a construction contractor. Appellant is both implying that the department should have known they were a construction contractor, despite their assertions to the contrary, and should have seen installation onto real property with zero evidence that the department ever saw invoices involving this type of labor. The simple fact is that the department never examined invoices involving installation for construction contracts with the U.S. government during the prior audits and informed appellant that it was reporting tax correctly. The standard is not the department should have known or should have seen. The standard is the department actually saw and reported and informed the taxpayer that they were reporting tax correctly. That did not occur in this instance. Thank you.
Thank you for your presentation. I'll see if my panel has any questions. Hearing Officer Wilson, do you have any questions for CDTFA?
I just wanted to clarify a couple things. It looks like in the first audit, on hearing binder page 926, there's some general comments.
Just to clarify, that's Exhibit K, page 5.
Okay. On this page, it looks like there's a couple comments here. The first one is the category tax returns, and it says taxed sales were traced back to this worksheet. So is that just since the actual audit wasn't in the file, I was trying to I'm not sure exactly what was provided, or is there any indication?
Hi, Hearing Officer Wilson. This is Jason Parker. In looking at the file and the information provided, this was a no change audit. So there was limited working papers for the audit. And so it appears that the auditor traced these amounts to the returns and the worksheet probably with the returns. But there aren't really working papers for this type of transaction in the audit.
Okay, I did notice that it was only 24-hour audit, so I was thinking it was a no change, but I couldn't determine that from the file. Okay, next question for the second audit period. I noticed it's a hearing binder page 1072. Under the penalty comment, it says the taxpayer was made aware of the proper reporting procedures for their ex-tax purchases and maintenance parts consumed. Would that have been in regards to any U.S. government contracts, or do you know what that was about?
I can double check real quick, but my understanding is it was for consumables that they assessed use tax on in the audit. But I'm not sure if there were consumables on U.S. government warranty contracts that they were consumers of. But I'll double check that and see if I can figure it out.
Yeah. That's all I had for now. I'll wait to see.
Mr. Parker, did you mean you're gonna look at that now or?
Oh, it may take me some time, so if I can figure it
Okay,
out before the end, I'll try to respond.
thank you. Judge Ridenhour, did you have any questions for CDTFA?
Just to clarify though, it was Exhibit L, page 126, that our hearing officer Wilson was referring to. Is that correct? Just for my own. Okay, thank you. Yeah, no further questions from me at this time. Thank you.
Thank you. Okay, Mr. Gustafson, you have reserved 30 minutes to make a closing statement or a rebuttal to CDTFA's presentation.
Yes,
You
thank you.
may proceed when you're ready.
My apologies and thank you. I it would be more just to respond to CDTFA's argument, and I'd like to start at the end where we really do seem to be arguing past one another in that CDTFA takes for granted that Eaton is a construction contractor in this discussion, and it was found to be a construction contractor in this discussion, which the third and fourth auditors did find that. But you have to get there. So CDTFA assumes that we're already there somehow, and we are not arguing that the standard under 6596 is that the auditor should have known something. We are not arguing, as in the appeal of Perveen, that the auditor there was enough there. They should have found, they missed something. That was a factual mistake. There was a factual item, the reimbursements or that were missed. That's not what we're arguing here. We're saying that the first auditor in particular saw the invoices to the United States government. They examined the transactions with the United States government and Eaton providing the invoices that it did, and determined that these were exempt sales. It did not determine that Eaton was a construction contractor. And that's based on what was on the invoices. You determine if the products on the invoices, the UPS products. CDTFA repeatedly refers to fixtures. That is a legal determination. The auditor can identify products and say, well, is it a fixture or not a fixture? Here, as CDTFA concedes, the first two audits categorized Eaton as a seller of equipment. And with regard to the contracts themselves, the underlying contracts, which Judge Ridenhour, I believe you asked about, and then was mentioned by CDTFA. The first auditor looked at the invoices, didn't ask for any contracts. Eaton certainly provided everything that the auditor asked for. The third auditor, looking at invoices, asked for the contracts, and if there are no fixtures, if there is nothing there to raise the question as to why, well, I should look at these contracts, then that's telling Eaton that in itself is a determination that these are not construction contracts. That if this is equipment, then under regulation 1521 A1 capital B1, that the sale of equipment, sale and installation of equipment are not construction contracts. So we don't get to this whole question of, well, now we need to see the contracts, now we need to see the purchases, because the issue of the taxpayers' Eaton sales to the United States government was examined. And even if the invoices to the US government didn't specifically say installation, the invoices to other non-government entities certainly had installation, and Eaton was selling the same products to these other companies, but these first two auditors, neither of them said you are a construction contractor of any kind. Whether something is a fixture doesn't depend on if it's used for a government contract or a non-government construction contract. The definition of fixture is the same. Because and what CDTFA was just saying was that the looking at the invoices was sufficient to find from the third and the fourth audit to find that they were a construction contractor, and spur the inquiry for the contracts. Well, in the first two audits, they considered it something different, equipment. So there was no need to go beyond. So if this were, and so Eaton is being told two separate things. First, your sales are exempt sales to the United States government, and that shows up in the work papers. It is shown in the labeling of its sales to the U.S. government as exempt in the audit work papers at Appellant's Exhibit 3. So this was Eaton being told it was reporting correctly. I think there was a couple of times where CDTFA was mentioning these gentlemen were mentioning that it wasn't that Eaton was told it was reporting correctly. Yes, it was. It was told it was reporting its sales to the U.S. government correctly, and that is sufficient for it to be relief from liability when Eaton reasonably relied on that. So that's all. Thank you very much.
Thank you. All right, one more time for the panel. Hearing Officer Wilson, did you have any final questions?
I do not, thank you.
And Judge Ridenhour?
No, thank you, everybody.
Panel, Mr. Parker
Mr.
had
Kim, sorry. Go ahead.
to the earlier question that was raised. Jason?
Yes, go ahead.
Yeah, hi, Judge Kim. I did, in response to Hearing Officer Wilson's question on the second audit, there were some transactions where they were found to be the consumer of parts provided for maintenance. So if you look at, this is Exhibit L, page 1123, line 53, has a transaction to the U.S. Naval Air Weapons Base, and there are $16 worth of parts consumed under that maintenance contract. And then on page 1126, line 102 and 106 had a couple more transactions involving the U.S. government. So there are some U.S. government transactions where we assessed use tax on parts consumed under maintenance contracts in the second audit. Hope that answers Ms. Wilson's question.
Yes, thank you.
Thank you. All right. Thank you both for the presentations, everyone. I don't have any additional questions. This case is submitted on January 21st, 2026, and the record is now closed. Thank you everyone for participating today. My panel and I will meet to deliberate this appeal, and we will issue a written opinion within 100 days of today. Today's hearing in the appeal of Eaton Corporation is now concluded. And this concludes the hearing calendar for today.